Hello everyone, good evening. I am CA Pooja Garg from Educating, and today we have Advocate Divyanshu Agarwal with us to deliberate his lecture on the topic of recent judgment in assessment under Section 153C of Income Tax Act. The short brief of CA and Advocate Divyanshu Agarwal is like he is an advocate and practicing in Supreme Court, Delhi High Court, Allahabad Court, and other high courts as well. He is practicing in National Company Law, Appellate Tribunal, ITAT, National Company Law Tribunal, etc. also. He is also a fellow member of the Institute of Chartered Accountants of India and has 17 years of professional experience and has work expertise with professional firms of repute like EY, PwC, Deloitte, etc. He has also worked in the chamber of renowned counsel of Allahabad High Court, senior advocate Shri Rakesh Ranjan Agarwal ji. He also worked in the chamber of renowned counsel of Delhi High Court, senior advocate Srimati Prem Lata Bansal ji. He has represented many domestic and international clients before the various forums like Honorable Supreme Court, Delhi High Court, Nainital High Court tribunals, etc. In few matters, the Honorable Principal Bench of NCLT has appointed him as chairperson of the meeting of the shareholder of the transferee company in terms of direction issued. We are very privileged to have you on our platform, sir, to guide our members regarding assessment under income tax. So over to you, sir.
Thank you so much, ma'am. Thank you. Thank you, team Educating. Thank you so much. The topic for today is very interesting. There are two recently judgments pronounced by Honorable Delhi High Court. This was pronounced in first and second week of April 2024 in relation to search assessment under Section 153C. So very interesting judgment. We'll discuss one by one both the judgments. So before that, it is equally important to for few of our participants and audience to understand what is 153C search assessment in case of other persons, and especially before knowing what is 153C, it is equally important to understand what is 153A. Let us first read the section to understand it properly before we go to the main judgments. So assessment in case of search or requisition. Let us read section 153A and important points which is there in this section to understand this section properly before we go to the main judgment. When 153A subsection 1 starts with notwithstanding anything contained which is highlighted in red in section 139, section 147, section 148, section 149, 151 and 153 in the case of a person where a search is initiated. Wherever the search is initiated, the assessment comes under section 153A. And the search was initiated under section 132, or books of account, other documents, or any assets are requisitioned under section 132A. After the 31st day of May 2003, but on or before the 31st day of March 2021. So friends, this 153A was introduced in the Income Tax Act effective from Finance Act 2003. So this is effective from any search which was happened from 31st day of May 2003 till 31st day of March 21. Finance Act 2021 effective from 1st April 2021 has changed the reassessment provision altogether. So any search which happens effective from 1st April 2021 and onwards under section 132, 153A section will never trigger in that case. So anything which happened, the search happened between 31st day of May 2003 till 31st day of March 2021, 153A triggers there. Now let us read what is the scope of this section. In this case, the assessing officer shall, which is mandatory, shall issue notice to such person requiring him to furnish within such period as may be specified in the notice the return of income in respect of each assessment year falling within 6 assessment years and for the relevant assessment year or years referred to in clause B in the prescribed form and verified in the prescribed manner, and setting forth such other particulars as may be prescribed, and the provisions of this act shall so far as may be apply accordingly, as if such returns were a return required to be furnished under section 139. So what is the important condition in this section is subsection 1 clause A says the assessing officer shall issue notice to such person. It is mandatory to issue notice to a person where a search is initiated, and the time period and everything is specified in the notice. And that is issued for 6 assessment years, and for the relevant assessment years referred to in clause B. Clause B says of subsection 1, assess or reassess the total income of 6 assessment years immediately preceding the assessment year relevant to the previous in which such search is conducted. If you understand it properly, it is very clear that the year of search, for an example, to understand this thing very clearly, if take an example, the year of search is financial year 1920. So 6 years we count effective from, we move backward. 6 years we count from 6 plus 1. 6 plus 1 means 1 is the year of search and 6 years preceding to the date of year of search. That means if I talk about assessment in 1920, then 1819, 1718, 1615, 1514, 14, 13, 14, 12, 13 comes also into 6 assessment years. And for the relevant assessment years, relevant assessment year is for 10 years. We'll come to the main section and then we'll interpret what does that relevant assessment year means. Second proviso, this is the first proviso of the 153A subsection 1, talks about that the assessing officer shall assess or reassess the total income in respect of each assessment year falling within such assessment year, 6 assessment year, and for the relevant assessment years. That means it is mandatory for the assessing officer to assess and reassess the total income of each assessment year starting from falling within 6 assessment years or for the relevant assessment years. So 6 assessment year, it is mandatory for them to assess or for the relevant assessment year. Friends, what does relevant assessment year means? A relevant assessment year is 10 assessment years. This provision was introduced effective from Finance Act 2017. We'll come to the main provision and then we'll discuss in detail what does that relevant assessment year means. Second proviso talks about provided further that assessment or reassessment, if any, relating to any assessment year falling within a period of 6 assessment years and for the relevant assessment years referred to in this subsection pending on the date of initiation of the search shall abate. What does this mean? This means that at the time of search under section 132, any assessments, take an example of a 3 assessment year matter is pending before learned assessing officer. So on the date of search, it is mandatory to keep the assessments under abate, to hold it there itself. An assessment can be under section normal scrutiny assessments or can be under reassessments under section 148. Second proviso talks about shall abate. Any assessments which is pending at the time of search, we need to abate that. I'm not discussing too much on the third proviso, which is not very relevant in today's case perspective. So I'm directly coming to the fourth proviso. Fourth proviso talks about provided also that no notice for assessment or reassessment shall be issued by the assessing officer for the relevant assessment year or years. Now, what do you mean by everywhere we are talking about 6 assessment years or relevant assessment years? Now, the question comes, what do you mean by relevant assessment years? Fourth proviso speaks about what do you mean by relevant assessment year. It says, unless the assessing officer has in his possession books of account, other document evidence which reveal that the income represented in the form of asset which has escaped assessment amounts to or is likely to amount to 50 lakh rupees or more in the relevant assessment year or in aggregate in the relevant assessment year. One of the condition is whatever the document they have, if in the form of an asset which has escaped assessment, should be amount to 50 lakh rupees or more in the relevant assessment year. If it is less than 50 lakh, then the relevant assessment year condition will not trigger. Then we only stick to 6 assessment years instead of all relevant assessment years. And the income referred to in clause A or part thereof has escaped assessment for such year or years. And the search under section 132 is initiated or requisition under section 132 is made on or after the 1st of April 2017. So friends, this fourth proviso is inserted in the provision in the section effective from Finance Act 2017, which is effective from 1st of April 2017. So prior to between 2003 till 2031st March 17, there was a provision of only 6 years, 6 plus 1 year, which we talked about in 153A for opening a case. but effective from 2017 onwards till 31st March 2021. Why I'm telling 31st March 2021? Now, effective from 1st April 2021, in case of any search under section 132 or requisition, this 153A provision will not come into picture. So these are the three criteria. If we fulfill these three criteria, then only or relevant assessment year condition comes into picture. Now let us read, what do you mean by this thing? Relevant assessment means how many years comes into relevant assessment year. This is specified in explanation 1 of section 153A. For the purposes of this subsection, the expression relevant assessment year shall mean an assessment year preceding the assessment year. Please read it properly, friends. Please understand. Shall mean an assessment year preceding the relevant assessment year, preceding the assessment year relevant to the previous in which search is conducted or requisition is made, which falls beyond 6 assessment year, but not later than 10 assessment year from the end of the assessment year, relevant to the previous in which search is conducted or requisition is made. What this explanation is telling, so in case, let us take an example to understand it properly. In case the search happens in April 2019, for an example, which comes under financial year 1920, assessment year 2021. So for assessment year 2021, as we have already discussed, 6 years we count, we go backward for 6 years. Assessment year 2021 means 6 years starts from 1920, 1920, 18, 19, 17, 18, 16, 15, 15, 14, 14, 15, 13, 14. We go like this. But relevant assessment year means 10 assessment years. For extra 4 years, you need to based on the checklist, you need to actually fulfill the condition which was there in the 4th proviso, above 50 lakh and above, all these conditions. But for 10 years, the condition is 10 year is a capping. That means the year of search you count as a 10th year. If I talk about in our case, assessment year 2021 is the year of search. Then 2021, we start the counting from 2021, and then we move backward. 2021 is year 1, and then we'll move backward till 10 years. So 6 plus 1 and 10, in case of the condition specifies and fulfills into that, friends. This is all about what do you mean by relevant assessment in explanation 1. Explanation 2 says, now everywhere we are talking about the word called asset in proviso in relation to our definition of relevant assessment year. Asset definition is defined in explanation 2 of this section. For the purposes of the 4th proviso, asset shall include immovable property being land or building or both, shares and securities, loans and advances, deposits in bank account. This is an inclusive definition which is given in explanation 2 of section 153A. Now, if any, now let us move to now what we have discussed. Before moving to subsection 2, let us see what we have discussed again. 153A to understand properly. 153A subsection applies when a search or a requisition happened between 31st day of May 2003 till 31st day of March 2021. Once a search happens, it is mandatory for an assessing officer to issue notice to such person. And then what if the periods is specified in the notice, and this the person concerned has to file a return for 6 assessment years and for the relevant assessment year or years. And this is mandatory for the assessing officer to assess or reassess all those assessment years, 6 year assessment years or relevant assessment years. On the date of search, whatever the return, on the date of search, whichever year is pending for assessment, wherein 143.2 notice was already been issued, or 142.1 is already pending, or 148 has been issued, then the assessing officer shall keep those matters under abate category. They'll keep it on hold. Then again, they'll restart the proceeding under section 153A for those years which is pending. Again, I'm repeating, this is the cases wherein the assessment is pending, not completed. Then comes everywhere we are talking about relevant assessment year. Relevant assessment year is the certain conditions in case anything which is 50 lakh and above, then or these 3 conditions has been specified wherein the search is happening between 1st April 17 to 31st March 21, then only this condition of relevant assessment year of 10 years comes into picture. We have already discussed for 6 years how we count. The section says 6 plus 1. the year of such, we take it as +1. And from the assessment year of such, we'll go backward for 6 years. Same thing for 10 assessment years. The highest capping is 10. So year of such, we take it as a 10th year, which is the year, and then we'll go backward for 9 assessment years. Now let us see what the subsection 2 talks about. If any proceeding initiated or any order or assessment or reassessment made under subsection 1 has been annulled in appeal or any other legal proceeding, then notwithstanding anything contained in subsection or section 153, the assessment or reassessment relating to any assessment year which has abated under the second proviso to subsection 1 shall stand revived. As you remember that under the second proviso, the law talks about whatever be the pending assessment shall be abated. So in this case, what is happening? In this case, it says if that particular 153 assessment for those assessment years has been annulled in any appeal or any legal proceeding, means maybe in a writ petition or something, then in that situation, those pending assessment which was abated earlier shall stand revived with effect from the date of receipt of the order of such annulment by the principal commissioner or commissioner. So there is a provision of revival under subsection 2, and such revival shall cease to effect if such order of annulment is set aside. Interestingly, the tax which shall be chargeable at the rates or rates as applicable to such assessment year. There is no special rate defined for 153A. For 6 assessment year, if you're opening a cases under 153A, so every assessment year, whatever be the rate of tax is applicable in the case of 153A proceedings also. This is 153A, friends, wherein how you do an assessment in case of a person in whose cases the search under section 132 or a requisition under section 132 happen. This is the procedure. This section talks about the procedure of assessment of a person and in which case the search has happened. Now, very important thing, after discussing and understanding 153A, now we go to 153C, a very relevant section which talks about assessment of income of any other person. Before we come to section 153C, let us take an example. Income Tax Authority under section 132 search of premises of X and company. During the search, they have observed that certain transactions of cash happen wherein the name of Y and company is specified therein. So who is Y and company? Y and company is any other person. So what an income tax officer do? For X and company, obviously the procedure comes under 132. X and company, the assessment procedure is under section 153A, which we have discussed. The whole idea of discussing 153A is to understand the differences between 153A and 153C. To understand this section properly, this helps you in understanding the issue which was before Honorable Delhi High Court, what was the contention taken by both the sides, and then what was the observation of Honorable Delhi High Court in the judgment. This helps you in understanding. So now we are moving to 153C section, and to understand what is 153C and what is the differences which is coming between 153 and 153C, to understand these sections properly. 153C subsection 1 starts with notwithstanding anything contained in section 139, section 147, section 148, section 149, section 151, and section 153, where the assessing officer is satisfied that any money, bullion, jewelry, or the valuable article or thing seized or requisitioned belongs to, and any books of account or document seized or requisition pertain to, or any information contained therein relates to. Now, friends, see, earlier we have gone through 153A, wherein it talks about the assessing officer is supposed to issue notices for 6 assessment year or the relevant assessment year. But see the difference in 153C. It says the assessing officer is supposed to be satisfied. They're supposed to record a satisfaction note, which was not there in 153A. These are the fine line of distinction which you need to understand between 153A and 153C. Where the assessing officer is satisfied that any money, bullion, jewelry, or the valuable article thing seized or requisition belongs to is important. or any books of account or document seized or requisition pertains to any information contained therein relates to a person other than a person referred to in section 53. For an example, we have discussed search on XN company, entries found of YN company. So YN company, then the assessment of income of YN company happens in the case of any other person. As soon as an AO of a such person has identified that these documents, bullion, money, jewelry, valuable article, things belongs to any other person, then the books of account or document or asset seized or requisition shall be handed over to the assessing officer having jurisdiction over such person. Step 2, friends, and that assessing officer shall proceed against each of such person and issue notice and assess or reassess the income of the other person in accordance with the provisions of section 153A if that assessing officer is satisfied that the books of account or documents or assets seized or requisition have a bearing on the determination of the total income of such other person for 6 assessment years immediately preceding the assessment year relevant to the previous year in which such search is conducted or requisition is made, and for the relevant assessment years referred to in subsection 1 of section 153A. Now friends, interestingly, try to understand. I'm just keeping a pause on this. What is this? What is step 1 in section 153C? Step 1 in section 153C is an assessing officer of a search person is supposed to record a satisfaction that money, bullion, jewelry, or other valuable article or thing seized or requisition belongs to, or any books of account or document seized or requisition pertains to a person other than the person referred to in section 153. First is the step 1 is a satisfaction recorded by a assessing officer who has a jurisdiction over a search person. Then step 2, after recording of the satisfaction, the assessing officer of a search person is supposed to hand over all these documents, money, bullion, jewelry to a assessing officer having jurisdiction over a such other person. Shall be, what is shall be? It is mandatory. Number 2, step 2 is handover. Step 3 is starts from if. Step 3 is then the assessing officer who is a jurisdiction officer of other person has to record a satisfaction that the books of account or document or asset seized or requisition have a bearing on the determination of total income of such other person. For every assessment year, he is supposed to record a satisfaction, whatever information, document, books of account, money, bullion, jewelry, valuable article, thing he has received from the search person EO. Whether whatever then is it impacting the other person assessment having a bearing on the total income of such other person for every year in the 6 assessment years or 10 assessment years which we have discussed. And if he is satisfied, then step 3 says, let us move further. We go to the 4th line of this slide, and that assessing officer shall proceed against each such person and issue notice. So step 4 is once you are satisfied, then you move and issue notice. And what is the procedure of issuing notice? The procedure is same which we have discussed in 153A. So in this case, you issue notice under section 153C for 6 assessment year or 10 assessment year. Before moving further, I'm again repeating, friends. Step 1, assessing officer having a jurisdiction over search person is supposed to record a satisfaction note that these items or the books or the information belongs to other person. Step 2 is he or she is supposed to hand over the books, document, information, money, bullion, jewelry, valuable article or thing to the jurisdictional AO of other person. Step 3, after receiving these things, this jurisdictional AO of other person is supposed to record a satisfaction wherein he has to see that all these document or assets seized have a bearing on the determination of total income of such other person for 6 assessment years or not. If yes, then step 4, then he issue notice under section 153C and follow the same procedure which we have discussed in 153. These are the 3-4 steps which we need. The process has to be done under section 153C. First proviso says, provided that in case of such other person, the reference to the date of initiation of search under section 132 or making of requisition under section 132A in the second proviso to subsection 1 of section 153A shall be constituted as a reference to the date of receiving the books of account or document asset seized or requisition by the assessing officer having jurisdiction of such other person. What does this say? So in 153A, we talks about date of search is the date of search under section 132. But in 153C, you would consider date of search as the period when the books of account was handed over, the same year, handed over to the jurisdiction assessing officer or the person. Take an example, the search happened in April 2019, which is financial year 1920, assessment year 2021. But the books of account was handed over to them a year down the line, which is April 2020, financial year 2021, assessment year 21-22. So from the perspective of 153C, we consider the first date, the date of handover of the document as assessment year 2021, the date, the year in which the books has been handed over to him, instead of the date of. So that's the fine line of distinction between 153A and 153C. Let us move to next, subsection 2. This is the fine line of distinction, and I'm not going further into that. That is not very relevant for a judgment. So before these, this is the fine line of distinction between 153A and 153C, friends. Now let us see what does that judgment talks about. I believe, my friends, you know now what is section 153A. You know what are the process of 153A. You know what is section 153C. What are the steps we have discussed? What are the steps there in 153C? Now let us see what does this judgment talks about. Now it is easy to understand this judgment. First judgment which we are taking was pronounced on 9th April 2021 in the case 2024 in the case of Saksham Commodities Limited versus Income Tax Officer Ward 22-1 Delhi, writ petition 1459/2024. A month before. What was the issue which was before Honorable Delhi High Court? The issue was whether merely because incriminating material may have been found or discovered and which would pertain to a particular assessment year, the same would constitute sufficient basis for initiation of assessment or reassessment proceeding in respect of 6 assessment years preceding the year of search or the entire block comprising the relevant assessment year as defined by explanation 1 to section 153A of that. In a simple language, if you have received the incriminating material from the AO who has done a search which pertain to a particular assessment year. Take an example, 2 assessment year. This incriminating material is related to 2 assessment year. The question is it a sufficient basis for initiating assessment or reassessment in respect of 6 or 10 assessment year? When the incriminating material only talks about 2 years, why would we are supposed to open the cases under these sections for 6 or 10 assessment year? That is the first question. The issue before Delhi High Court. Now another issue, whether completed assessment which may fall either within the ambit of 6 preceding assessment years or probably within the scope of relevant assessment year, reassessment can be initiated only in respect of those assessment years corresponding to which material may have been discovered in the course of search, and basis which the AO of the other person would have the opinion that the same is likely to have a bearing on the determination of total income or such entity. Friends, in 153A, we talks about shall abate, which is the proviso. So any assessment which is pending can be abated. Let us now move to other person cases, wherein the assessment has already been completed. So whether based on the document or the information you have received, can you reopen those cases under section 153C or not for those 6 assessment years? The question before Honorable Delhi High. So this is very important. Even if you have received a material, my question is again, even if you have received a material, if you have received, the issue was very simple. We are trying to tell the honorable, we are trying to ask a question from the honorable court that whether my original assessment or my reassessment originally has already been concluded, but some incriminating material has been received which talks about those particular assessment year. Can we reopen? Yes. In case of 153A, yes, you can reopen. In case if it is specifically indicating a relation, if the particular material related to completed assessment year. But now in case of 153C, we have a threshold. So if you believe that is related to those years, you need to, as the assessing officer of the other person is supposed to record a satisfaction wherein he is supposed to form an opinion that whether whatever the material the person has received, whether it has a bearing on the determination of total income of the non-search entity or not. That is very important. So 153C has more parameters and the criteria which was not there in 153A. This is only this is an issue also before Honorable Delhi High Court. Whether the requirement of incriminating material existing and thus constituting the basis for invocation of 153C would be liable to be reviewed on identical terms. Even in those cases, assessment may come to abate. Next question was, requirement of incriminating material can be viewed on identical terms for both completed and assessments as well as assessment which is abate or not. These were the three issues which was before Honorable Delhi High Court. Now, to understand it properly, it is important to see what were the various contention of the petitioner before the Honorable Delhi High Court. The power to reassess or assess conferred by virtue of section 153C of the Act is premised on the AO of the non-search entity being satisfied on a perusal of the material handed over to it that the same would have a bearing on the determination of total income of the other person for 6 assessment year immediately preceding the assessment year relevant to the financial year in which the search was undertaken or document requisition as well as for the relevant assessment year as defined in section 153A of that. Now, let us read what are the various relevant part which we have highlighted and read. Premised on the AO of the non-search entity being satisfied on a perusal of material handed over. As soon as you received a material, which we have discussed, friends, in 153C, what were the discussion? First point, AO of a person of search, wherein you have done a search, has to record a satisfaction that yes, these document, material, jewelry, article belongs to other person. Step 2, after recording a statement, he is satisfaction, he is supposed to hand over those things to the jurisdiction of other person. Okay. Step 3, the other person, AO, has to record his satisfaction that look, these incriminating material relates to these particular assessment years, and these incriminating material has an impact, have a bearing on the determination of total income of the person. If this condition is not met, obviously they cannot reopen the case under section 153C. So what they are saying is that they, based on the material, the assessing officer of the non-such person has to record his satisfaction, and only then they can continue with 153A process, which is defined in 153C. That was the contention they have taken. Existence of material which is likely to impact the total income as determined or assessed for any assessment year is a sine qua non for sustaining the initiation of action under section 153C. So existence of material is very important. It was also submitted that the reopening of all assessment year which may form part of the block of 6 or 10 assessment would not be justified merely on the ground of incriminating material having been discovered pertaining to a particular assessment year. So friends, the contention which was taken by the petitioner before the Honorable Delhi High Court was that whatever the material they have received must relate to a particular assessment year. Blindly, just by having a material of 1 year or 2 years, you cannot reopen all the years cases. And yes, whatever the material they have received, you're supposed to see whether it is impacting the total income of the particular assessment year or not. If it is yes, then only you can go, and after that satisfaction, you can go and follow the process given under section 153C. Certain judgments was quoted and the reliance was there, wherein one of the judgment which we have relied was on Honorable Supreme Court, one Kabul Chawla judgment of Honorable Delhi High Court, RRJ Securities of Honorable Delhi High Court, Ram Avatar Verma judgments of Honorable Delhi High Court, Honorable Delhi High Court judgment ARN Infrastructure India Limited, one of the Supreme Court judgment in the case of 153 Abhishar Buildwell Private Limited. After analyzing all those judgment, these were the judgment which was relied by which were relied by the petitioner before the Honorable Delhi High Court. Now next comes the contention of the respondent. Let us see what was the department contention before Honorable Delhi High Court. This is very interesting to understand what was the contention taken by the respondent before them. First was, the contention was taken that at a time when the jurisdictional AO comes to issue notice under section 153C of that, it has yet to examine the material in detail so as to assess the impact that the same may potentially have on the income for the period of 6 assessment years or the relevant assessment years. Friends, the contention which was taken by them that they have, at the time of issue of notice, they are supposed to examine, they have not yet examined the material in detail to understand the impact of the income for the period of 6 assessment year. So what is their contention was the preliminary, they are supposed to issue 153 notice, and after that they'll go and do all these process. That was one of the contention, which was not the intention of the legislature, but the contention which was taken by the respondent. According to learned counsels, it would be wholly incorrect for the AO, being required to have formed a definitive opinion with respect to the income pertaining to the block of 10 assessment years individually for each assessment year. According to learned counsels, the jurisdictional AO would be justified in initiating action as long as the material gathered is likely to impact the assessment of total income of any one particular assessment year forming part of block which comes to be thrown open. So friends, very interestingly, another contention taken by the respondent was that the AO is justified in initiating action on whatever the material they have received, even if they have a likely to impact the assessment total income of any particular assessment year. What they are saying is that even if a material has an impact only one assessment year also, in spite of that, they can go and reopen the cases under a block of 6 or 10 assessment years. Though that is not the intention of the legislature, but this was the contention taken by the respondent in this case. They contended that the underlying statutory scheme of 153C is liable to be recognized as warranting the entire block period of 10 assessment year being scrutinized, even though the proceeding may have been triggered by material that may pertain to a particular assessment year. Contention taken was, even if the material relates to a particular assessment year, they are supposed to issue notice and in under section 153C for a block of 10 assessment year or a 6 assessment year. These were the contention. Now, friends, interestingly, now you know what is 153A section. Now you are aware what is 153C section. What is the difference between 153A and 153C? Now you know what was the issue before Honorable Delhi High Court in this case. You know what was the contention taken by the petitioner. What was which all judgments they have relied. What was the contention taken by the respondent. Now we move direct. Now let us see what was the observation of the Honorable Delhi High Court. Reopening or abatement would be triggered only upon the discovery of material which is likely to have a bearing on the determination of total income and would have to be examined bearing in mind the assessment year which are likely to be impacted. So it is triggered only when the discovery of material is likely to have a bearing on the determination of total income. So every material, whatever you have received, if that has a bearing on the determination of total income of the person, then only then, and which year it is impacting, you have to keep in mind this thing. Then only you are supposed to trigger that assessment, reopening or abatement. It would thus be incorrect to either interpret or construe section 153C as envisaging incriminating material pertaining to a particular assessment having a cascading effect and which would warrant a mechanical and inevitable assessment or reassessment for the entire block of the relevant assessment year. So every incriminating material, you have to see which assessment year it relates to, and then you need to see whether it has that particular assessment year has a bearing on the determination of total income. If yes, then you can go for 153C notices for those year only. You cannot go for the entire block. Now let us see. The Honorable High Court has given an observation regarding the flow of events. What is the flow of events contemplated under section 153C? Firstly, the receipt of books, satisfaction record by AO of a person on which search has happened, then handover of the books from the person AO to a jurisdictional AO, other person, which is firstly the receipt of books, accounts, document, or assets by the jurisdictional AO, an evaluation and examination of the contents, and an assessment of the potential impact that they may have on the total income of the 6th assessment year. Immediately preceding the assessment year pertaining to a year of search and the relevant assessment year. It is only once the AO of the non-search entity is satisfied that the material coming into its possession is likely to have a bearing on the determination of total income that the notice under section 153C would be issued. So once you have a material, you need to see which year it is impacting. So year, you take those years and then you see whether it has a bearing on the determination of total income of those years. If yes, so first is the year, then the bearing on the determination of profit. If yes, then you can issue a notice under section 153, otherwise not. Abatement would thus be a necessary corollary of that notice. However, both the issuance of notice as well as abatement would have to necessarily be preceded by the satisfaction spoken of above being reached by the jurisdictional or non-such entity. Now, if you wanted to abate the proceeding, under section 153C, it is equally important that before that, prior to that, 4 categories, 4 steps has to be complied in the case of 153C. Satisfaction recorded by the AO of a search entity, handover of the books of account by the AO of such entity to the jurisdiction of other person. 3. After examination of those material, the AO of a non-search entity is supposed to record a satisfaction wherein he has to record that this particular incriminating material relates to which assessment year and whether those assessment year has a bearing on the profit or determination of total income or not. If all these conditions has been complied, then only you can go and issue a notice and can await the proceeding of the pending assessments. Abatement of the 6th assessment to the relevant assessment year would follow the formation of that opinion and satisfaction in that respect being reached. So we have already discussed, friends, this thing. So after meeting all the criteria, then only you can go for an abatement. And abatement means you are going to issue a notice under section 153C. So that at that stage you go and trigger an abatement process for the pending assessments. That the incriminating material which is spoken of would have to be identified with respect to the assessment year to which it relates, or may be likely to impact before the initiation of proceeding under section 153C of the Act. So incriminating material which we are talking about is to be identified with respect to the assessment year to which it relates. So every incriminating material you need to see which assessment year it is related to. Then only you think of initiating a proceeding. So one is incriminating material related to which year, number one, and those years, whether it has a bearing on the profit of the determination of total income or number 2. If these 3 conditions you are connecting, then only you are supposed to go and issue notice under section 153C. A material, document or asset recovered in the course of a search or on the basis of requisition made would justify abatement of only those pending assessments or reopening of such concluded assessments to which alone it relates to or is likely to have a bearing on the estimation of income. The mere existence of power to assess or reassess the 6th assessment year immediately preceding the assessment year corresponding to the year of search of the relevant assessment year would not justify a sweeping or incriminate invocation of section 153C. We have already discussed whether it is pending assessment or completed assessment. Incriminating material relates to those particular assessment year, and after that they are supposed to form an opinion whether it has a determination on the profit of the determination of total income or not. If both the condition has been met out, then only you go and issue a notice and invoke the provision of section 153C. Next, the jurisdictional AO would have to firstly be satisfied that the material received or is likely to have a bearing on or impact the total income of years or years which may form part of the block of 6 or 10 assessment year, and thereafter proceed to place the assessee on notice under section 153C. The power to undertake such an assessment would stand confined to those years in which the material may relate or is likely to influence. Absence of any material that may either cast a doubt on the estimation of the total income for a particular years, the AO would not be justified in invoking its powers conferred by section 153C. It would only be consequent to such satisfaction being reached that a notice would be liable to be issued and thus resulting in the abatement of pending proceedings and reopening of concluded assessments. So friends, Saksham Commodity says a very particular ratio is coming from this judgment. In the case of other person, which is 153C, 4 criteria has been specified. Number 1, after 4 criteria, it is equally important to see the incriminating material which you have received is related to which assessment year. Whatever, if it is related to assessment, take an example out of 10, block of 10 assessment year, if it is related to 2 assessment year only, then those 2 assessment year as an assessing officer of a non-jurisdictional entity, assessing officer of a non-such entity, you see whether it has an impact, likely to have a bearing or impact on the total income of years or not. If yes, then you please go and issue notice for those 2 assessment years only. If no, then you are not supposed to issue notice under section. So if you believe that the incriminating material is related to 1 year, but it has an impact on 3 years or 4 years, assessing officer or non-such entity is supposed to record those things in his satisfaction note itself. And then after that, he is supposed to test this thing whether all the years, concerned year or years, is actually, it has an impact on the bearing on or the impact of total income or not. If yes, he is supposed to record those satisfaction, and then only he can issue notice under section 153C. So friends, this is very good judgment, very relevant judgment. Whenever you get time, definitely please go Please read this judgment. This is a very good judgment and a good ratio laid down by the Honorable Delhi High Court after analyzing all the latest judgment on the same and after considering both the counsel's respondent as well as petitioner's contention. Next judgment is, friends, pronounced by Honorable Delhi High Court on 3rd April 2024 in the case of Ojas Medicare Private Limited. It talks about the timelines, how you compute the timelines of 6 assessment years or 10 assessment years, which we are consistently talking about in 153 and C. This is related to section 153C, friends. Now, the issue before Honorable Delhi High Court in Ojas Medicare is the manner of determination of 6 assessment years and relevant assessment year in case of non-search other person under section 153C. Certain background, which we are not discussing so much, just a background. Pursuant to search in case of certain group of on 18th October 2019, Income Tax Department alleging incriminating material having been found issued notices under section 153C to a number of assessors. For that purpose, Income Tax Department determined assessment year to be reopened by taking previous year 1920. That is a year of search as the base year and accordingly reopened assessment for 10 preceding assessment year, 1011 to 1920. Income Tax Department also initiated proceeding for the search year, thereby undertaking assessments to 11 assessment years. So friends, in this case, what is happening? The year of search was 1920, which is the base year. That means 1920 is 2021 assessment year. So they have taken 2021 assessment year as a base year, and then they have computed 10 assessment year going back. So they have computed this thing as 10 plus 1. Year of search as 11th year and then backward as 10 years. The grounds of challenge before Honorable Delhi High Court in this matter was, a batch of matter was, the notices issued under section 153C came to be challenged in a writ petition before Honorable Delhi High Court as being invalid or barred by limitation of the following 4 broad grounds. In the case of other person covered under section 153C, the date / year of handover of seized material to the jurisdictional AO of such non-such other person must be taken as a base year for determination of 6 assessment year relevant assessment year. This was the first ground. So, handover of seized material to the jurisdictional AO of such non-such person, we should take those as a base year for determination of 6 or relevant assessment year. Number 1. Number 2. Revenue is permitted to reopen up to a maximum 10 assessment year, including the year of search / year of handing over of seized material reckoned from the end of the assessment year in which search was conducted or the material is handed over and not 11 assessment year. Second ground was taken as the year of search, total maximum 10 assessment year is available with the revenue. And handing of material of such material, the year we take it as a base year but as a 10th year. So we need to go backward for 9 assessment year. So there is no concept called 10 plus 1 assessment year. 10th is the highest capped year. What was the ground of challenge before Honorable Delhi High Court? Period of limitation for initiating reassessment proceedings for assessment at 10, 11, 11, 12 stood expired prior to the insertion of 4th proviso to section 153A. Now, what this talks about, friends? So there was a provision of 6 assessment years only. 6 plus 1 assessment year concept is only till Finance Act 2016, which is till 31st March 2017. So effective from Finance Act 2017, which is starting from 1st April 17, which we have discussed in 153A 4th proviso, there was a provision inserted in 153A which talks about anything having 50 lakh or above impact. We can open cases for 4 more assessment years, 10 years. But interestingly, when this provision was inserted into the act, what the ground was telling is that whichever assessment year was already time barred. For an example, take an example of assessment year 10-11. So friends, 10-11 was 6 assessment. You talk about 12, 13, 14, 15, 16, 17. 10-11 was time barred prior to the insertion of Finance Act 2017. And 11-12 was also time barred. So what they are trying to tell, now you cannot go back to those years and can reopen those cases, though those cases were already time barred prior to the insertion of 153A. Prior to the insertion of this Finance Act 2017 provision. This was the ground which was taken before Honorable Delhi High Court. And now mandatory condition provided in 4th proviso to section 153 are required to be satisfied prior to invocation of jurisdiction to reopen. Another point which we have taken was, so for relevant assessment of 10 years, that is extra 4 years, there was a fourth proviso which was inserted in 153A. So it is what they have taken the position that those conditions is supposed to be met by the assessing officer before invoking those provisions. So I'm again repeating the grounds of challenge we have discussed. What first ground was year of handover of seized material should be taken as a base year. Number two, the revenue is permitted to reopen up to maximum 10 assessment years only, not 10 plus 1, 11 years. Number three, 2 assessment years at time barred prior to insertion of Finance Act 2017, a fourth proviso. And fourth is mandatory condition of fourth proviso. These are 4 grounds of challenge taken before Honorable Delhi High Court. Now let us see what does Honorable Delhi High Court decision view on the same. Friends, Honorable Delhi High Court has taken a position in this judgment after hearing the contention of both the sides. As per legal fiction contained in first proviso to section 153C, date of receipt of seized books or material by the jurisdictional year of the other person is the commencement date for determination of 6 assessment year, relevant assessment year. So friends, the contention which was taken by the petitioner in this case has been accepted by the Honorable Delhi High Court. What they are saying is that whatever be the date of receipt of seized book or material is the commencement date for determination of 6 assessment years. First, 6 means that's a base year. We'll count 6 years from those years only, or 10 years. First decision, very good decision. Second decision, taking note of the language employed in explanation 1 to section 153A, the court held that the 10 years period have to be reckoned from the end of the assessment year. That means in case of a search person from the end of the assessment year of search, and in case of other person from the end of the assessment year of handover of seized books or material. So 10 year is the last year capping. So 10 years we counted in the case of search person from the date of search, end of the assessment year of search, and in the case of non-search entity, whenever from the end of the assessment year of handover of seized book or material. This was the second position taken. Third, AO is required to record reason satisfaction regarding the satisfaction of jurisdictional preconditions stated in fourth proviso to section 153A. So in case assessing officers invoking the extended period of 4 years in a block of 10 assessment year, as per the fourth proviso section 153, he is supposed to record the satisfaction that the condition has been met in his satisfaction note prior to invoking the fourth proviso, issuing notice for those years. Third thing, fourth, satisfaction should be based on the assessment of material gathered during search and should be reflective of the fair assessment of the quantum income likely to have escaped income. Fourth point says, whatever the material they have gathered, it should be based on the fair assessment of the quantum of income likely to have escaped income. That means if it is 50 lakh or above aggregate, so then you are supposed to record everything in your satisfaction note. So satisfaction note is a very important document which plays a very important role. And importantly, the satisfaction cannot be based on mere speculation or conjunction. The reasons in support of the satisfaction should ex facie support brought out from the satisfaction note. Whatever be the reason you have taken must come out from the satisfaction note itself. The qualifying category criteria for satisfaction of precondition of 50 lakh is provided in fourth proviso has to be met cumulatively or in aggregate for all the relevant 4 assessment years. So 50 lakh condition is not for 1 year. Even if it is for other 4 years also, even in aggregate 50 lakh is coming, yes, you can go for that. The court has said, yes, the condition of 50 lakh in the fourth proviso has to be met cumulatively or in aggregate for all the relevant assessment years, 4 assessment years. Amendment brought in by the Finance Act has retroactive application since both provisos is applicable to all searches conducted between 1st April to 31st March. And section 153 and C supersedes the provision for reassessment otherwise appearing in that. So friends, what does OJUS Medicare talks about? OJUS Medicare talks about, let us conclude this thing. The OJUS Medicare talks about, number 1, year of handover of material by the jurisdictional AO of such entity to the jurisdictional AO of non-such entity. We should take that as a base year for computing 10th year or this thing. Number 1, this was the first point. For 10 years concepts, the total capping is 10 years. There is no concept called 10 plus 1 years. So 10, which if the 10th year you're talking about, the block 10th year is the year of handover of the material is the 10th year. You take it as a base year and take it as a 10th year. There is no concept called 10 plus 1 year. You need to record the satisfaction. You want to reopen the cases for extra block of 4 years, whether they are exceeding 50 lakh or not. Proper assessment is required and to record the satisfaction. These things are very important, friends. So friends, these two judgments, Saksham Commodities and Ojas Medicare, are the very two important judgments on 153C. It talks about the timelines, how you compute the base year, what is the role of satisfaction note, which incriminating material you consider, whether it has an impact on other years or not. The Honorable Delhi High Court, after analyzing all the judgments, after hearing both the sides, has given a detailed judgment, detailed observation in this. So this is going to change the way we see 153C notices. This judgments gives us a guidance how to handle those 153 notices, whether if the proper mandatory condition of the statute has not been complied, whether invoking a writ jurisdiction in those cases is correct or not. This guidance we get from these judgments, friends. So this is all about, we talk about 153C. So in case if anybody has any query, just please let me know. What are you?
Hello everyone. So our today's deliberation has been ended. Thank you, Divyanshu sir, for giving us your time and explaining the both judgment in such details. I hope it will be very beneficial to all of our viewers and members. Thank you so much, sir. Thank you.
Thank you so much, ma'am. Thank you.